go live. So I record first on Zoom, and then I also record on Facebook. So just in case anything happens. Hello, everybody. I believe I am live now. Hello, everyone. This is Edward Reyes with Jurex Bar, and it is the end of January. And I remember when I was studying for the bar exam, and sometimes I would get some panic attacks. Oh my God. Like I would say, you know what? I haven't gone over this issue. I totally forgot about it. I need to go back. Okay, so I understand I understand the stress that you are going through. And I do want to say this. I actually have some very good news when it comes to the essay written portion of the exam. And that is that a lot of times these issues just keep popping up, the same ones. So today I do want to go over constitutional law. I do want to go over the case United States versus Trump. I'll show you what you need to know about that. I will go over the new abortion laws, Dobbs, and I will briefly discuss the lemon test and the updates. I did make a video about that earlier, so I don't want to focus too much on that, but I also want to say this, that for these issues here, they're collected in the cheat sheet templates, and you could get that document, you could get that study material, the e-version of that, by just going to patreon.com counter underscore argument. That's my Patreon site, and it's only $19.99. This is one of the study materials you get, and there's more, so it's really a good deal. So if you're not on that yet, if you're not on it, man, you're missing out. I'm telling you. Okay, great. So hopefully you guys can see my screen. I am sharing my screen. So let's go ahead and jump into this. Look, there's not that many issues. Okay, not that many issues. Cookie cutters. Um, Man, sometimes I get essays and they just discuss 11th Amendment, government standing, moving this right. Man, I say, look, if anything, just focus on maybe standing, maybe if there's a government actor there, and just discuss that briefly, if at all, because modernly people aren't discussing all these issues anymore at the beginning. And I've seen people that just kind of waste valuable times talking about these issues, and they're usually non-issues. Just keep that in mind. Commerce clause. Sometimes you get hit with that. I'm gonna show you a smooth pattern here. So what you do is, of course, you discuss the Commerce Clause, black letter law. The Congress has the power to regulate instrumentalities, all that. You guys know that. And then, of course, what they're really testing you on is the Dormant Commerce Clause. So you have to know that. So in your black letter law and your rule statement, talk about discriminatory or unduly burdensome elements there. Great. Okay, so then what happens after you discuss that? Okay, and then start thinking about the offenses to the state, because remember, the state is the one that's going to write the regulation, and some other party outside of the state is gonna challenge that. So that means that the state needs defenses. What's a common defense? By the way, let me enlarge this. Let's see. Okay, there it is. You definitely have to know the market participant doctrine. States non-economic interests, no less discriminatory alternatives. You have to know those as well, but definitely know the market participant doctrine. So the reason I'm focused on this one, on number 3, is because I want to show you the structure, the pattern here. You dormant clause, then dormant, the commerce clause, and then the state defenses. And once you get that pattern, and then you're good, you're great. And this subject confuses a lot of people. And I'm like, hey, look, just take it easy, follow these structures, follow the structure here. Okay, so of course, right now you're at that moment where you're like, okay, where do I get my rule from? Okay, so if you have a rule, great. If not, just go with these rules here. States non-economic interest. And I like these cheat sheets because they're they're just they're just the absolute crucial elements that you must know that are commonly tested. Of course, you have your outlines, big outlines there, and some of those issues aren't tested, so you're just kind of wasting your time. For the MBE, great, but when you're studying for the essays, this is what you have to know. Okay, so again, the defenses under the dormant commerce clause for the state's non-economic interest, and there's a balancing test, no less discriminatory alternatives, and of course the market participant doctrine. Okay, and you're good. You go through those steps and you're great. Okay, at least a 65. And further reading there, due process. So sometimes they may the call of the question may say under procedural due process what defenses. Sometimes they'll say under due process. So then you have to think, should I discuss just procedural or just substantive or both? Sometimes they'll say under the Constitution. Okay, what defense is under the Constitution? So yeah, you have to. We'll run through these, and then that'll help you. That'll help you decide. But just keep in mind, you might not have to discuss both. And if you feel a little unsure, then discuss both, but discuss one thoroughly and the other one just very briefly. And then that way you just feel like, okay, great. You feel you maintain your confidence. Procedural due process. Think about the Eldridge standards there. Fundamental life, liberty, the importance of that interest, safeguards. Okay, let's see now. And then we move on to substantive due process. And before I had a different mnemonic. Notice that it doesn't have abortion anymore. So marriage, education, and privacy. We'll discuss abortion right now. Okay, so of course there's a Supreme Court case, Dobbs versus Jackson Women's Health, and it pretty much says that abortion is not a fundamental right. Let me say that again. Abortion is not a fundamental right. Rational basis review is the appropriate standard to apply when the state abortion regulation undergoes a constitutional challenge. Okay, so let's get away from that. Okay, and then of course we go into strict scrutiny, the black letter law. And I noticed that there's different, the wording might be different. So again, if you have your own black letter law, that's great. If not, just use this. Okay. So that was simple, right? That was the new abortion law. Equal protection. Equal protection. Okay. Now that's when you go into the different standard of review. Okay, and of course you have the classification. You have to know what classification is. But of course you have the 3 levels of review. We already talked about strict scrutiny, intermediate, rational. Okay, so let's talk about 3 categories. Okay, so when you have race, alienage, national origin, that's going to invoke strict scrutiny, intermediate scrutiny, suspect class, gender, legitimacy. You guys pretty much know all these, so I'm not going to get too much into these. Okay, so let's move on to privileges and immunities. And you guys know that doesn't apply to corporations, so that might be included. Just discuss that briefly. Okay, presidential powers. Here we go. So there's actually, you do have to know the black letter law as far as the powers, not the defenses. We're not talking about United States versus Trump here. Okay, but there are powers when there are times when the president's power is at the apex, when it's given pursuant to him by Congress. Okay, so it's not always going to be cut and dry. So you might have a gray area. And here it is right here. Okay, so the courts are split, and then you also have in the face of congressional disapproval. All right, so then that may not be an actual power of the president. So that kind of reminds me, right, of the supremacy clause. Okay, when you have the federal law versus the state law. Okay, so that kind of reminds me of that. Okay, but just know, okay, when it's in the powers vary, the powers of the president vary when it's at the apex, when it's in the face of congressional disapproval, and when it's a gray area. You can look at this exam here, July 2008. Okay, and then we have, okay, of course, domestic affairs and foreign affairs. So you have to know that as well. All right. Immunity to former presidents. Okay, so there's the black letter law there. Let's go ahead and go through that. Just remember that immunity. Okay, let's go through it, and then I'll highlight the key parts that you must know. It says presidential powers requires that a former president have some immunity from criminal prosecution for official acts during their tenure in office. So make that distinction. It doesn't apply to non-official acts. Okay, it says at least with respect to the president's exercise of his core constitutional powers. So we went through that already, right? This immunity must be absolute. As for the remaining official actions, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether the immunity must be absolute or instead whether a presumptive immunity is sufficient. So all that means is that just remember that the powers apply when it's during acts, official acts during their tenure in office. Okay, so all right, let's move on. That wasn't hard, right? That was pretty simple. Speech under the First Amendment. Okay, so you have your let's see, initial test. What is this? Okay, commercial speech. This was tested in the past, it hasn't really surfaced lately, but still know it. It just says here that commercial speech is proper if it is not false advertising and not illegal. So in the past, you had a fact pattern that I think they were trying to sell cigarettes. So yeah. All right, let's see. Standard of review, commercial speech. Okay, there it is. There is the test. Okay, so now let's move away from that. Again, I'm just telling you issues that you absolutely must know. Okay, constitutional limitations. These are very common. Prior restraint, overbroad, vagueness, unfettered discretion. You must know these. Okay, and I'm not going to go into these too much. The prior restraints, key element there is, well, key wording is speech cannot be enjoined before it occurs. Overbroad prohibits more speech than is constitutionally allowed. Vagueness, one cannot tell which speech is prohibited and which is allowed. Unfettered discretion, where an official is given complete discretion. Okay, so again, know that. Content neutral versus content based. Again, apply your own rules there. Content neutral. Okay, it doesn't focus on the actual content. And that's where you get the TPM, right? Time, place, manner. And then you also have your forms there. That would be under neutral speech, not content based. Okay, let's see. Then you might want to, I highly suggest you take a look at this exam, July 2004, question 3. Then we go to content based, where it focuses on the actual content. There's the test there. Okay, and of course, strict scrutiny might apply there. Okay, then you go into symbolic speech. And yeah, that was tested. When was that test? 2014. You had the people who worship the sun. Okay, so there's your test there. Okay. Let's see now. Oh, okay. And yeah, so a lot of these are going to invoke strict scrutiny. My suggestion is when you get hypothetical and you have all these issues, try to use strict scrutiny at least once. So don't use it every single time. It's not going to be worth your time. And yeah, I think that's a good because of course you could use it in every single issue, but you just have to see based on the facts. They'll usually be focused on one issue where you say, hey, look, you know what? I'm going to apply strict scrutiny here. Okay. And that's where you could use your counter argument. So, and I haven't talked about the counter argument, but that's one thing you want to keep in mind for all these essays. You do want to use the counter argument. Always. Obscene speech. I'm not going to get too much into that. Religion and First Amendment. So free exercise clause. Okay. So that's where we have the general applicability. Okay. Let's see now. So let's go ahead and read the free exercise clause, and then we'll go into the establishment clause. Okay, so it says here the free exercise clause prohibits the government from preventing one's free exercise. Laws of general applicability are permissible while laws that target a specific religion meet strict scrutiny. So if someone wants, okay, so what's an easy way to understand that is that if the law specifically targets an act that a particular religion practices, then that's going to invoke the free exercise clause. What's one example? One recent example is somebody praying. Okay, that's going to violate the free exercise clause. Okay, now let's talk about the establishment clause. It says here, let's see now. Okay, so this has been updated. And I'm just going to go through this very briefly because, again, I did make a video on this in the past. So it says when a law or policy is facially neutral, okay, does not discriminate against a particular type of religion, then the First Amendment violation occurs when historical practices and understandings of the Establishment Clause are violated. So no historical and practices, know those terms. You must know that. And what does that mean? How do you define that? So you focus on these three elements there: neutrality, general applicability, and the actual Establishment Clause. Let's go through them individually. Neutrality. So of course you state that, and if this surfaces on your exam, just state the black letter law and then say, hey, look, I'm gonna discuss three factors there. And let's go through them now. Neutrality, where the policies are not neutral because they target religious speech. Again, they're not neutral because they're focused against the particular religious speech. General applicability, whether the policies are not generally applicable because they are specifically applied to a person's religious exercise. Think about individual prayer. So let's talk about this. This is kind of confusing. Yeah, this is whether the policies are not generally applicable. Okay, so general applicability is when think about it this way: they're across the board. There are policies across the board that do not target a specific religious act. Okay, if they do target, and then they are not generally applicable. So that's a factor to consider, whether general applicability is present. If there's no general applicability, then it might be stricken. It might be a violation. Okay, and then you go on to the Establishment Clause. Discusses very briefly whether the actions of the government are not justified because they are based solely on the Lemon Test. So the Lemon Test, in many ways, has been it has been abandoned. That's the word that the Supreme Court used. It's been abandoned. It was abandoned in Kennedy versus Bremerton. So keep that in mind, please. Okay, so let's move on. Taking, okay, no, definitely no regulatory taking. I know government action must take all the reasonable use or value of the property. And there's partial taking, lengthy there. I'm not going to get too much into that. 13th Amendment, that was tested only once when you had, when there was, the state was using labor from students that had dropped out. They were making them work in the forest, something like that. Okay, so that was tested. Okay, fantastic. So yeah, definitely know all these rules. If you have any questions, send me a message. My email is jurexbar@google.com, gmail.com. Okay, everybody, wish you all the best of luck. So let me go ahead and stop sharing my screen, and I'm going to end this on both Zoom and Facebook. So it's